Jeremy Brumley is suing his former girlfriend, Cheyenne Madewell, for a bed and his belongings.
Court come to order.
Have a seat, everyone.
Hello, Judge. Case number 1120, Brumley versus Madewell.
Thank you. Mr. Brumley, how old are you?
I'm 32 years old.
How do you support yourself?
I was unemployment recently, and I'm working for a contractor at the moment.
Unemployment recently, from when to when?
For the last year and a half. I don't have the date, Your Honor, exactly.
When did your unemployment end?
It just recently ended.
What state do you live in?
Oregon.
So party's over, back to work. So for a year and a half, you collected unemployment. How much did you receive every week? Don't think I would know. I know exactly what they put in my bank.
718 or like 720 a month, or a week.
$720 a week.
Not counting the whole extra, it's 700, because with the COVID, they added an extra 300 to your weekly claim. I made $458 a week until the extra 300 was going on. So during that whole time, it wasn't the whole seven, it was 458. During COVID, they added the extra $300 with the COVID kicker.
Now, you are 32 years old.
Yes.
So prior to collecting unemployment, what kind of work did you do?
I worked for a contractor. I
Doing
replaced
what?
water meters for the city and water box contracts in Bend as well.
Now, what were you doing when you met the defendant online?
I wasn't working at the time.
So you were collecting unemployment?
Yes.
Who were you living with?
I was living with my grandma and kind of some friends at the time because I dealt with the breakup, so I was kind of a few different spots.
And you met the defendant online in what month?
That would have been end of February, beginning of March.
Of 2020?
This year.
2021?
Yes.
And the defendant was living in her grandmother's house, in a room.
Yes.
In what month did you move in with her in her room, in her grandmother's house?
Beginning of April. Or end of March, beginning of April. We got together March 23rd in relationship-wise. I was trying to figure out.
And a week later, you moved into her room?
No, not a week later.
2 weeks later?
It was a couple weeks.
3 weeks later?
3 weeks to a month, yes.
3 weeks later?
Yes.
And you stayed there until when?
I didn't technically stay there. I would give her rides to work, and I'd come stay sometimes in the beginning, and then I'd leave. And then after a little bit, she needed a ride to work constantly, and so then I'd be like, okay, I'll give you a ride to work, and then she offered for me to stay there with her. And
what month did she offer to let you come and stay there with her?
April.
April?
Yeah, that'd be like April
Okay.
1st. We'll say that's, yeah, sorry.
April. So in April, you came and stayed with her full time?
No, it was never full time, Your Honor.
Okay.
On the weekends, she'd visit her family. On weekdays, I would give her rides home. And in the beginning, I wouldn't even stay there.
No, I'm talking about when you started to stay there.
Yeah.
You started to stay there long enough, sir, so that you got disgusted with the bed, because that's what most of your lawsuit is about. You say you bought a new bed for her grandma's room, and when she terminated the relationship, you want her to pay for half the bed. So you don't need a new bed unless you're sleeping there. So let's be real. That's what the lawsuit's about.
Lawsuit's about a bed. Yes.
A bed.
For the most part, the bed, my clothing, and my belongings.
Well,
yes.
just a second, your belongings. According to you were never there. According to you, you didn't stay there. You just drove to work, and sometimes you stayed over, and sometimes you didn't.
Your Honor, sorry.
So put on a whole new thinking cap.
Okay.
In what month did you move in there enough so that you wanted to change the bed?
Well, it was kind of a her thing, too. Like, I don't know exactly April, but we wanted to get a bed, and it was mutual. Like, we wanted to get a bed. We were together. We were trying to, like, move forward. And I have that stated here that, like...
I don't care what you have stated anywhere. I'm going to make this suggestion to you, sir.
Yes.
She terminated her relationship with you. I haven't even let her open her mouth yet. I understand why. So my advice to you is, in case you move in with somebody and you don't like the bed again, get twin beds so that you can take one with you. Because she can't cut this bed in half, and she's not paying you for half of it.
Excuse me, Your Honor. She said that she would pay me on here, that she would do that. She's like, you buy the bed, and I will pay you part for that, too, and I have that right here.
I'd love to see it.
And if I may, Your Honor.
No, you may not. Such a blessing. Just tell me when you need money. We're a team. That's not a contract.
Well, it says right here, you're getting it with the Amazon card, and she's having me
No,
buy
she
it
said,
with it.
yeah, I'll give you money back, or you just tell me when you need money, baby. We're a team. That's not a
Yeah,
contract.
After the situation.
That's not a contract.
Okay, I understand that with the bed.
Okay, it's not a contract. Contract requires specific terms. If you buy the bed, I will reimburse you for half the bed. Not, yeah, I'll give you money back, or you just tell me when you need money, baby, and we're a team. That's not a contract.
Okay.
Okay, so get twin beds. Now, the next thing comes with a question. When did you move out?
I moved out June 3rd, or no, it was before that. She told me on June 3rd that she was breaking up with me, and that, or no, she was taking care of her grandma and moving states away to deal with that. And I was like, okay with that. which is totally fine. I don't know what's going on. She's just been cold turkey for a little bit. Like, I don't know what's going on. She's been super quiet, so I just didn't understand. And then this happens, I take it as it is. I'm not a heartless person at all. Don't get me wrong.
Just a second.
And
you moved in there, according to you, sometime about the second week in April, part-time.
Yeah.
And then you moved in more full-time. But you left on June 3rd. So you were there for the month of May, right?
Actually, we'll say the end of May, because June was when she wrote me and said this stuff, so I
Just a
hadn't been
second.
over there then.
So tell me when you were there.
I'd be there during the weeks sometimes with her when I...
And where were you living the time that you weren't
I was at
living?
my grandmother's.
Is that where you get mail?
I have a P.O. box. Grandma gets tired of getting my mail, so...
How long have you been staying at your grandmother's? Since this last breakup that you had before her?
It's kind of off and on, but I'm just kind of figuring out my life, Your Honor. I stayed with my grandma a little bit.
You did say you were 32.
I'm 32, Your Honor. Like,
Well, you're a third done. And that's if you're lucky. You better start figuring it out, sir.
Jeremy Brumley claims his former girlfriend, Cheyenne Madewell, owes for a bed and his belongings.
You better start figuring.
excuse me, Your Honor.
I said, you're 32. That means you're a third done. If you're lucky, because not all of us get so lucky to live to be 96. 96, so I'm saying to you, you better start figuring, because the last third isn't as good as the first two thirds. Trust me on that.
Your Honor,
Mr. Brumley,
can I?
Mr. Brumley,
Yes.
get yourself real, will you please, sir? You don't get the bed. You live there on and off with your grandmother, with whom you don't pay any rent. You live there. You didn't pay any rent or expenses. You live part-time. You live half-time. You live out of your van. You live out of your car. You couch hop with your friends. Okay, now I want you to tell me what items specifically you allege that she disposed of that were yours in this place that you really don't live in all the time because you're mostly with your grandmother. So tell me what specific items, and I'll see receipts for them.
The best that I could do for receipts was to be able to go to Amazon or Google and look for different items for each item that I had inside her house.
First, try telling me. I don't care what you
I got
take pictures of.
PlayStation games. I have my...
Just a second. Hey,
Yeah.
you had a PlayStation there that you brought to her house.
Yeah, and then she changed my network password to her name for no reason, because she's controlling it.
Where did you get the PlayStation and when?
I bought it offline. The marketplace had probably been a year or so before we got together, so I had it for at least a year.
And how much did you pay for it?
I paid
Offline.
$250.
What did you do with his PlayStation?
I have the evidence right here, Your Honor. I messaged him when I was moving out of my grandmother's house. He was taking 8 showers a day. He was staying home.
But listen to me. I'm
I
not
had
giving
the
you.
PlayStation
I don't.
still to this day. I asked him to pay me the money that
Just
he
a
owed
second.
me.
Just a second.
Yes.
So you still have the PlayStation?
Yes, ma'am.
Great. One PlayStation to you. Know your address?
He knows my address, Your Honor.
So what I want you to do is on 24 hours notice to you. He's going to pick up the PlayStation. Do you have a porch?
I have the front yard where I actually left his stuff. But yes, I have a porch.
Good. Leave his wrapped PlayStation on the porch. And that's on 24 hours notice to you.
So when you say 24 hours notice to me, I contact him if he doesn't?
No.
Okay.
He's going to contact you within 5 days
Okay.
of today's date.
All right.
And say, I will be there on the 3rd at 9 a.m. Take a photograph of it with a time. Put it out there. If he picks it up, fine. If he doesn't, it's gone.
All righty.
Okay. So that's the PlayStation. What else is there?
There's a bag of my clothes that I had there. I'm not sure
Okay.
exactly what I had, but I have a bag of my clothes out on the street.
Just a second. Can I see that photograph?
I actually had that too, ma'am.
Just
Sorry.
okay. So this is a bag of clothing that was his, that you put out and that you received. She said to you in this picture, here are your clothes.
Yes, and you have till Friday or Sunday to come get them. And then I told her Sunday I would come there.
Just a second. She sent you a picture of your clothing out in the street.
Yes.
You live in the same town.
No, I don't.
Where did you live?
I live in McMinnville.
And how far is that from where you were living with her?
It's not too far from
Not too far. So she sent you a bag, picture, and said, come get your stuff. I don't want this bag of your clothes here anymore. And you didn't go get them.
Yeah, and I have a statement saying to come Friday or Sunday to come get your stuff. And I said, Sunday, can I come get my stuff? And I didn't get a message or anything. I have messages of that too.
Then I would have run over and gotten this
Animosity
garbage
that's
bag of
going on, I
stuff.
didn't want to go into a fire right then. You know?
Okay,
I was like,
very,
if I have
very
an option
good.
to Friday or
Okay,
Sunday, I'd like
very
to.
fine, very good. Bed, we finished. Return of value of property, we finished. Your case is dismissed. We're done here. Get a job.
Court is adjourned.
We had a relationship of a month and a half to 2 months. It's not very long.
People aren't who they seem to be when you first meet them.
But also, like, that's enough for someone to get in to know someone and take advantage of them.
They have a mask over them, and you got to get to know them and watch that mask come off. And once that mask comes off, you're just like, whoa, what is this?
I'm not sure. I got a text message on that, and then this soon after it happened.
I was actually really nice about it. I told him that it was over, that I was moving out of my grandmother's house. With me moving out, well, obviously you're homeless, so you can't go with me.
I'm gonna save my money, and I'm gonna get a way better job. And nobody make $47.50 like that. She ain't.
It's time for me and my daughter, not no man.
Now, Sarah, I know many people, not well, but many people who have met on sort of dating apps and have had long-term relationships with them. Even some got married. You could not tell that by our program.
No,
We don't
it always
have
seems to go south.
Not one successful go-around. Why do you think that is?
I'm not sure. You've got to go through a lot of profiles to find one that you could be in a long-term relationship with, I guess.
You know, I would say for most thinking women, mostly, 'cause it's usually that's what we see here, women who end up on the short end of the stick. The first thing that they should have is a job.
Yeah.
That's prerequisite one. You could actually understand why this young man didn't have a job, because he made more not working than he did working, which was a big problem and will continue to be in this country a big problem, but has been over the last year. And that really is a country making babies out of a whole generation of people.
I agree.
Joseph Zelmer is suing auto technician Richard Neff for car damages from an oil change.
Court come to order. All rise.
Be seated, please.
Hello, Judge. We have case number 1080, Zelmer versus Neff.
Thanks, Captain.
Come.
Mr. Zelmer, you're suing Mr. Neff because you claim that as a result of his negligence, your car required thousands of dollars worth of repair.
Yes.
Mr. Neff says that he did work on your car, changed oil, and changed some sort of an O-ring. He said he did all of that work properly. Any subsequent damage to your car is not his responsibility. That's what the case is about, correct?
Correct. Yes.
Okay, great. So tell me, what year, make, and model is this car?
2015 BMW 535i,
And when did you purchase it?
November 2018.
So you purchased it used from whom?
CarMax,
How much did you pay for it?
$30,000.
When you purchased it from CarMax, was there a warranty on the car?
There were 2 warranties. There was remaining time on the BMW manufacturer's warranty,
How much time?
about a year, I believe.
Okay.
And I bought an extended warranty from CarMax also,
For how long?
2 or 3 years.
So then the warranty would have been good until October of 2021.
Under those terms, the fine print, they asserted, and I agreed with them that this repair was not covered.
I assume you have that warranty with you.
I do not. I have not read
just a
that.
second.
I have not read that in years.
Well, that's not my problem. And just so that I'm clear, how much did you pay for this extended warranty from CarMax?
I believe $2,500.
Now, you noticed that there was something wrong with the car. In what month and year that brought you to the defendant's mechanic shop?
July 2019.
So about 6 months after you bought it. Certainly well within the warranty period.
Yes.
Certainly a $2,500 warranty lasts for a year. You said 2 or 3. Okay, and the equipment that you put in, other than oil, was an O-ring.
Well, we did the oil and filter, and part of the oil filter is replacing the O-ring also.
Okay, very good. So you began to have trouble in July 2019. You called CarMax.
Not yet.
Who did you call?
The problem that first manifested was small drops of oil in the garage.
I've seen that.
An oil leak, yes. When I knew that I needed service, I contacted CarMax and said, this might need to be fixed also. And they said, take it to our approved repair center, which was Performance Center down the road in Auburn.
That was his.
Correct.
I'm beginning to love this case.
Is that a good thing?
Not for you. And you took the car into him for an oil change because you were going on a trip.
Not imminent, but soon. My wife's birthday, yes.
Well, you began seeing trouble in the beginning of July. When did you first contact the defendant?
I'm sure I made an appointment a couple days before he did the work on July 30th.
So let me understand. You saw leaks of oil in your garage on the 2nd, and you didn't deal with it for a month.
True.
And you picked up the car on what date, Mr. Zelmer?
Probably same day, July 30th. I also asked him to fix the oil leak.
Mr. Neff, did he ask you to fix the oil leak?
Yes, he asked me to take a look at it and see if I could tell what was leaking.
And did you do that?
Yes.
And what was leaking?
There was oil all around where that O-ring sits and running out of it. So it had been installed improperly.
Did you tell him that?
Yes.
Let's go back to you, Mr. Zellmer. What he said to me was that he told you that the previous O-ring had been installed incorrectly, so there was oil.
That's not true. He did not say that. He said what we see on the receipt that he gave me.
And I have it documented right here to be caused by sealed oil filter last time oil change was performed.
May I see it, please?
It's on the second paragraph.
Kevin, would you show this to Mr. Zellmer and tell him if he recalls seeing that?
I'm sure I did.
And whose signature is at the bottom of that?
That looks like mine.
Well, I'm going to read to you the diagnosis, which clearly supports what he says. Find out the source of the oil leak. And he says he told you what that was. It's written in here and signed by you. Diagnosis. Found oil leak to be caused by improper sealed oil filter. Tech cleaned the area off and ran with no current leaks observed. Recommend customer have engine steam cleaned to remove residual oil. So you were told by the defendant there was leakage, and he told you at the time that you should have the engine steam cleaned because there still may have been residual oil from the leak. Okay, now that's on the 30th of July. And I'm assuming that you never had the engine steam cleaned before you went on your vacation.
Correct.
And where do you live?
Nevada City, California.
And where were you going?
Bodega Bay on the coast, about 4 hours.
And on what day were you going there?
Around September 17th was my wife's birthday.
So you drove the car the entire month of August?
Yes.
And had no issue?
Correct.
Did you notice any more leakage from the oil in your garage?
I did not.
So for the entire month of August and half a month of September, there was no additional leakage from anywhere that was visible to you?
Correct.
And for at least a month before that, you had seen leaks in the garage from oil from the car. That's what you testified to.
Talking tiny, occasional drops.
Okay, so now September 17th, you're celebrating your wife's birthday. You're taking the car on a 4-hour drive. Did you reach your destination?
We did.
Now you can tell me what happened with the car.
Joseph Zellmer claims auto technician Richard Neff caused engine damage after Richard changed his oil.
Okay, so now September 17th, you're celebrating your wife's birthday. You're taking the car on a 4-hour drive. Did you reach your destination?
We did.
Now you can tell me what happened with the car.
We made it 3 or so hours and about an hour from home, heading up Highway 70 north. Lights came on and the car basically ground to a halt. It wasn't quick. I would say it was over about a half mile. It just lost power, lost juice. We were able to get up to the top of an exit, pulled over, stopped, called BMW. They said, you need to have it towed.
So this is generally what you want. You spent $175 with the defendant to change an oil filter, change the oil, check a leak. And this is what I'm getting so far from the facts from you. The entire month of August, there were no issues with the car. On the 17th of September, you were a good husband. You made arrangements to take your wife for her birthday to a lovely inn. It was a 4-hour drive in each direction. There were no issues that you saw with the car while you were there. About an hour away from your home, which would be after at least 7 hours of highway driving, the car collapsed. And you want $10,000 from the defendant. That's what you're suing him for. Now, do you understand why you're in trouble?
Well,
you understand why you're in a little bit of trouble, sir.
That's why the trouble started.
Yeah. But it's my understanding from reading your papers that you have a witness. But before I get to your witness, sir, did you have the car towed back to CarMax?
No.
Where did you have the car towed to?
The BMW dealership in Roseville, California.
Did you call CarMax?
I definitely contacted CarMax as soon as the car broke down and I knew I was facing, at first I was told, a $7,000 bill.
And you're a smart gentleman. You contacted CarMax because it was your belief that they were responsible under their warranty.
I hadn't read their warranty yet, but I sure hope
well,
so.
you should have. You're a lawyer, are you not?
Yes, I am.
Just a second. Yes, you are a lawyer.
Yes.
And yes, you have a warranty. And yes, you should have read it before so that you know what it's covered. I mean, when I buy a car, the company gives you a warranty.
And you read them?
Just a second. Do I read them? Listen, I know what paragraph 9, subsection 6 of my separation agreement from my first husband says.
Okay.
So don't ask me if I read them. I read them. So, yes, well, you're paying extra for something for $2,500. The answer is, I would have read it before. But to me, the issue was not with this gentleman who did a $175 oil change, but with CarMax, who sold you a car for $30,000, charged you $2,500 for a warranty, but you had no warranty from him. You had a warranty from CarMax. And the defendant said to you, we recommend testify as an expert because you never saw the car before the oil was changed, so you never saw it with a defective oil ring previously, and I assume that you didn't see the car before it was fixed.
That's correct, Your Honor.
All correct.
All
correct. So what you're doing is you're testifying from notes.
That's correct.
Okay, so now tell me, who do you work for?
I have an independent BMW repair facility called BMW Autotech in Culver City.
How long do you know, if you know, Mr. Zellmer?
20 minutes ago.
Are you being paid for your testimony today?
I do?
You mean you are?
Yes, I am.
Yes, you are being paid for your testimony today.
I will be paid.
How much?
$400.
Now, the first time you met Mr. Zellmer was 20 minutes ago.
Correct.
When for the first time did you review the documents on which you are prepared to testify?
Yesterday.
Have you ever seen this document?
Yes, I have a copy. I saw that. Review that.
Good. Thank you. When you met Mr. Zellmer, or when you reviewed the documents, can you tell me, Mr. Benor, the car had engine trouble. The engine failed. Is that correct?
Not correct. It didn't fail completely. Some component failed.
Okay. And in any of the items that you read, did you see who fixed the car?
Yes, I did,
Who?
Your Honor. BMW of Roseville, California.
And how much did they charge Mr. Zellmer to fix the car?
About $5,500.
I don't want an about. This is a court.
May I answer?
Yeah, sure.
5456.95.
Okay. Now, understanding that you never saw the car before, you never saw the car after, and you were testifying solely based upon what you're reading.
Correct, Your Honor.
Is what you're reading indicate to you that there was oil somewhere in the engine?
Yes.
And that oil was the proximate cause of the trouble that the car had that Mr. and Mrs. Zellmer experienced on their way home from holiday.
That's the result of the oil leak, yes.
There was oil in the engine.
Around the engine block, yes.
Is there anything that you read that you can show me that tells you how long that oil had been there?
No.
So it could have been there for a month.
Could be.
Could have been there for 2 months.
Could be.
2 months, could have been.
Yes.
There's no way of knowing. But that corroded enough of the engine for it to fail on the 19th of September.
The date.
Yeah, okay, I see it.
Opened.
Now,
September 19th.
Okay.
now I want you to tell me, because I'm curious, since you just came upon this case and this information and me, I want you to show me where it is indicated that there was a current oil leak that caused this blow-up of the engine.
Attorney Joseph Zellmer has accused auto technician Richard Neff of using the wrong parts during an oil change, causing Joseph's engine to fail.
I want you to show me where it is indicated that there was a current oil leak that caused this blow-up of the engine. Don't say anything. Say nothing. Just point somewhere in the documents, because that's all that you can testify to. You never saw this car. No. You have a witness, Mr. Zellmer. You can't be both a witness and a lawyer. Otherwise, you're going to have to run up here and sit in the witness chair and then run back and ask questions, which would make it look very ridiculous. Show me in the documents that you read where.
On those two lines on the top of the BMW of Roseville statement.
I'd like to see it, please. So the line that you are referring to is leaking oil filter cap, non-BMW oil filter installed in vehicle. cap O-ring is hard, as if it was not changed during one or more oil services. That's what you're relying on.
That's what I'm relying on.
Just a second. I just want to make sure that that's what you're relying on.
Yes, Your Honor.
Okay. Now I'm going to ask you this question. I want you to assume the following, that on July 2nd, 2019, there was visible leakage from oil. That remained for a month. The car then went in for an oil change and a change of the O-ring on July 30th. The car was used from July 30th to September 17th.
Correct.
And there was no new evidence of an oil leak. Do you understand?
Yes.
Then it was driven for at least 4 hours.
Yes.
And after being driven for 4 hours, there was no evidence of an oil leak, no light, no anything. And then it was driven back. Can you explain to me how, with an oil filter and an oil filter change, that a car, and if it was a leaky situation, there would be no evidence of that for at least a month and a half?
Okay. The engine has a quantity of 7 quarts of engine oil. If you have a small amount of oil leak and it dropped to about 5 or 6 quarts of oil, the warning light will not come on, only if it's going below that level.
I'm asking you about when you lose oil, and what you're suggesting is that the oil goes below a certain rate. Well, it doesn't go to God. The oil goes down,
yes,
which is how Mr. Zellmer initially saw the fact that he had an oil leak in his garage.
I see.
And what I'm asking you, sir, is if the oil is still leaking, you would still see some sort of residue in the garage.
True.
For a month and a half.
True. You should see some small amount of residual on the floor.
If
the rest of the oil, if it's leaking, it could dissipate during driving. So you
it
won't
could, but it wasn't doing that kind of driving for a month and a half.
True.
So just as Mr. Zellmer saw the oil leak before it was fixed by the defendant,
correct,
should have seen some oil leak if it was still leaking.
Depends how much you drive, because the oil leak will not leak when the engine is not running.
Okay. The answer is it depends. Now you can sit down.
Thank you.
Mr. Zellmer, you and I both know that your complaint is with CarMax. It's not with the defendant. And if you chose not to go through a mediation with them, that's your problem. They sent you to their mechanic. Your complaint is not with him. You paid $30,000 for a car and $2,500 for an insurance policy in order to fix the car. You followed their instructions to go to a particular mechanic. You did. You had the car for a month and a half. You had no issues with the car because you're a smart man. And if you had seen oil leak before you took a 4-hour drive, you would have gone back to his shop and said, I still see oil. In addition to that, the defendant, when you picked up the car, gave you instructions. He said it is recommended that you have the engine steam cleaned because I can't tell where the oil got to parts that I can't see. He said that right in the document that he gave you that you signed off on when you picked it up July 30th. You sued the wrong party, sir. Go back to it. We're done.
Court is adjourned.
The car was at BMW Roseville, which was also under the BMW warranty if he hadn't used aftermarket parts.
It was an actual aftermarket part that is the same as BMW's part number.
They said they checked it out, and they sent me to the warranty provisions that says we don't cover this.
He had called me up sometime after the time we did the work, claiming that the whole housing was leaking, not that the oil filter was leaking.
And he didn't do the work that he said he did.
I think she did a great job. I did perform the work properly.
I think one of the main takeaways from today is make sure you have proper standing in court. Make sure you're suing the right person, the person most at fault. He doesn't really seem like the proper person to sue for this amount of money.
Well, it's an interesting case. If he had proven to my satisfaction, without hearsay evidence, that the work that he did caused a larger problem, he may have been successful. But while he brought his expert can only report from what he read, and what he says he relied on were the 2 lines that were in there. And even if he relied on those 2 lines, he says there's no indication that there was any active oil leak. And my other takeaway, he said he didn't read the warranty. Well, it would seem to me that you should have read before you signed it and paid over $2,500. You would read what you're paying $2,500 for. It's a very, very good lesson for everybody because even lawyers don't do it. Mm-hmm. Anyway, good case.
Read the fine print.
Yes.
Number 1147, Sanchez versus Sharif. All parties, please step forward.
Veronica Sanchez is suing tax preparer Darlene Sharif for the cost of legal document services and the loss of revenue.
Ms. Sanchez, what kind of business were you starting?
I was purchasing a chiropractic and acupuncture business.
Were you purchasing it from someone who had an existing practice?
Correct. The existing practice was a chiropractor, and I am an acupuncturist, so I had to purchase it from a chiropractor.
And was the chiropractor retiring?
Chiropractor was leaving the state.
So in effect, you were taking over his lease?
No, because since I'm an acupuncturist and they're a chiro, I did not purchase the business. I was purchasing the goodwill, so I started a brand new lease.
What was the name of the business?
Her business was called Inner Movement Wellness, a chiropractic corporation.
How much did you pay her for the name Inner Movement Wellness?
I paid $220,000.
And you signed a new lease with the landlord?
Correct. I have the lease, yes.
Just a second.
But now instead of Inner Movement Wellness, a chiropractic, it's Inner Movement Wellness and Acupuncture, a professional corporation.
Were you represented by an attorney in this $220,000
yes.
negotiation?
Yes.
And the name of that attorney was what?
Lee.
How much did you pay Mr. Lee?
We together paid him $6,000.
When?
June 7th.
Of this year?
Correct.
And you signed the lease when?
June 1st.
Now, you retained the defendant to file papers for you so that you could start to do business as Inner Movement Wellness, only you had to change it to an acupuncture. Is it a corporation or an LLC?
The acupuncture board says it has to say a professional corporation.
Okay. And when you hire the defendant, she's not a lawyer, she just prepares papers.
Well, she had done my son's nonprofit.
You know, she was not a lawyer.
Correct.
Mr. Lee was your lawyer.
Correct.
So she was supposed to file to get papers for you so that you could start your business.
So I can open up a bank account and start my business, yes.
On what date did you make initial contact with her? With regard?
On or about May 3rd or 4th, but I went into her office on May 7th.
Okay, this is what your case is about. We're going to go step by step. Went into her office on May 7th. You signed the lease on June 1st.
Correct.
You say the paperwork, because of her negligence, was delayed several months so that you paid rent for June and July. Did you ever get the paperwork from the state?
Yes, I did.
On what date?
June 30th, I received a workable S-Corp, but to this date, I don't have a DBA. To this date.
Just a second. So her work got you the paperwork that you needed to work by June 30th.
But she had promised to expedite it.
Okay, but she promised to expedite it, madam. It's COVID. Nobody is working. You can't even get a license plate. Well, so what you're suing for is the return of what you paid her, right? Despite the fact that you got your paperwork, and for your potential lost income for a month.
Actually, I'm only asking for just 3 days, not the whole month of June.
She's not paying you for that.
Okay.
Just understand this. She's not paying you for your potential lost income.
Well, I paid 3 times the normal going rate. My accountant was going to do it for $800.
Listen, you can't tell me what your accountant was going to do it for.
Well, no, it's the going rate.
Just a second. And you can't tell me what the going rate is. You don't have experts here.
I Googled
it. I don't care what you Googled. What I'm telling you is, if you can establish some sort of negligence on her part, and it has to be a serious negligence, most you can get is some sort of a refund from her.
Well, I tried to ask for one.
Don't speak. Just listen. Because she got you what you asked for. She got you the ability to work in a business in a relatively short period of time. Now, the only thing that I want you to show me is you filled out paperwork on May 7th. I would like to see the paperwork that you filled out with her in the office, because you say that because of her negligence, that paperwork came back once.
It came back 3 times.
Or it came back 3 times. So let me see what you filled out the first time. No, don't give me 3 letters. I want to see what you filled out with her. May I see that, please? So you went to her office and you told her that the name of your business was Inner Movement Wellness, a professional corporation. That's what...
Okay, I told her I needed an expert to help me because it was very...
No.
Veronica Sanchez claims tax preparer Darlene Sharif owes for the cost of legal document services after making several mistakes.
now. You have to understand, this is what it's all about. You tell her what the name of your business is.
But if she's an expert and is supposed to be able to help somebody who doesn't know anything about this, she's also supposed to guide me, and she didn't guide me correctly.
So, Ms. Sanchez, you told her that the name of your business, because you bought for $220,000, Inner Movement Wellness, a professional corporation.
And I also...
Just a second. Actually, what I find fascinating is you bought the goodwill of a chiropractor who had been in the same location, and you bought that goodwill, and the chiropractor did not have an acupuncturist there.
There is an acupuncturist there.
Did that acupuncturist come with you?
The acupuncturist continues to work there, yes.
With you?
Yes.
How many people work there?
I have 11 employees.
How many did you bring with you?
None.
They were all there?
Yes.
Now I got it. So, Ms. Sharif, did you get anything back from the state with regard to this application?
For the fictitious business name?
Yes.
No, it goes directly to my client.
It went directly to Ms. Sanchez?
Yes, it did. And
well, can I see it? Does somebody have it? Did they not accept it? What is the current name of the company?
To answer your question to the best of my ability, on June 30th, I did get the S Corp, and I do have this, but since she was going through a third-party LegalZoom, which I could have done myself.
Listen, you have to understand something. I don't care
Okay.
if what she went through is LegalZoom or any other app that gives lay people an opportunity to fill out paperwork. And if she decides to be an intermediary between you and LegalZoom or you and somebody else, that's her business. And if after it's all over you say, well, I could have filled out the same paperwork, so I want my money back, that doesn't happen.
No, but
that doesn't happen.
That's not why
I don't know what you want. You filled out these papers, and you have to show me where she did something wrong. Seems to me somebody who's paying $220,000 for a practice keeps the same lawyer. If they want a lawyer, if you want to do it on the cheap, you do it on the cheap. How much did she charge you for this?
She charged well above and beyond.
Don't chatter.
$2,600.
Okay, so she charged you almost half of that to get you the paperwork to operate as a business. That sounds penny wise and pound foolish to me. And the reason I'm short with you is you got what you paid for. You got the paperwork. And if my feeling is correct, it may not be, you're annoyed because you could have done the same thing through LegalZoom.
That's not why.
Now I'm going to see.
That's not why. It's because she promised expedited service, and it took months.
No, it didn't take months. Because once you fill it out and file it, somebody's got to look at it. Now let me see the first letter. No, don't give me 3 pieces of paper. Give me the first letter that you got from them, which is what she said you got. And initially you said you did not. Okay, so you have to understand, this came to you on June 1st, which means it took somebody in Los Angeles County, because this was sent in right away.
Right.
It took them almost a month to read it and respond to you. That's just a second. Just a second. That's not her fault.
No, I agree.
No. Great.
But had she done it right, had that been right, I could have started then right there.
Shoulda, woulda, coulda. If my parents had been taller, I may have been taller than 5 feet tall. That's a possibility.
And
my brother is 5'9". I could have been 5'9", and he could have been 5 foot tall. That's a shoulda, woulda, coulda.
But also to promise expedited service when somebody's like struggling to purchase a business and keep things going.
Ms. Sanchez, you have absolutely no case. You were up and running for business on June 30th, according to you. Is that correct?
Yes.
Now, the thing that you don't have is a DBA, which you have not received yet. Well, so far you have something pending with the Department of State, I assume, and that's doing business as.
Yes.
Listen, I'm going to tell you this. If you hire somebody else and they're able to, during this time when people are not in state offices, if you hire somebody else to get your DBA and pay them, you're free to come back to me and say, she was supposed to get me the DBA, and she didn't. For whatever reason, I had to hire somebody else and pay them. Then I'll talk to you.
Okay.
Right now, she has paid to get you up and running in your business. You have 11 employees who have been working for you for almost 4 months. As a result of this work that she did, she got you what you needed to conduct your business.
But it wasn't timely.
Goodbye. We're done.
Court is adjourned.
It's just unfortunate during these COVID times when mom and pops are trying to do their best.
Tell you, I really worked hard on her case.
That we still have people that want to take advantage and charge high prices.
But she just was very persistent and
overcharge and underdeliver.
I'm sorry that she's unhappy.
And waste people's time.
Judy Justice, she did me well.
I actually came away with two things. I think that the plaintiff was unreasonable. The process was completed enabling her to work in less than 60 days. That would be a reasonable period of time, even if it wasn't for COVID. The defendant enabled her, through her work, nobody else's work, to hire, employ, and make a living within 7 weeks of their meeting.
Yeah, almost impressive during COVID that it got done.
Almost impressive. So she's being unreasonable. And I honestly believe that her issue was that she could have done the same thing and filled out the same forms as the defendant did for probably $200. And the defendant charged her either $2,400 or $2,600. So she felt as if she was being scammed because she could have done it herself. Well, that's on you.
Yeah, that's something you want to look into before you engage with someone for their services.
Right. And she knew she wasn't a lawyer because, according to her, she had done work for the family before. I was unsympathetic.
I could tell.
David Bertolino is suing his former clients, Carrie Thompson and Christian Honigschlager, for breaching a verbal agreement to purchase his collectible posters.
Court, come to order. All rise. Hello, Judge. We have case number 106, Bernice versus Hornet Slater.
Thank you. Be seated, please. Let me see if I can set the stage here for this case so that I'm sure we're all on the same page. Mr. Bertolino, according to your complaint, you're in the collectibles business.
Yes.
You collect various things. My grandmother would call them tchotchkes. You go here and you see panda bears or ducks or figurines or posters, and you like them, you buy them, you eventually sell them. In this particular case, you were having a collectible sale of things that you had accumulated over a period of time. And were you doing this sale in your home or in a place of business?
It was artifacts, collectibles from my two previous businesses that I've retired from. So it was an estate sale to liquidate.
In your home?
Yes.
Okay, and that's your business, right?
It was.
Okay, because I've really always been curious, and since this is my program, so I can ask whatever questions that fulfilled my curiosity over the years. Could you explain the difference between an estate sale and a tag sale to me?
Estate sale, generally someone is selling off everything, their collectibles over a long period of time.
Collectibles, furniture, artwork, etc. They're everything from an estate, as opposed to a studio apartment or a one-bedroom apartment.
Now, very often when you respond to that, it's generally somebody who's passed on and their children are doing the estate sale. In this case, I had a little deterioration of health, and so my...
I'm not talking about in your case. Sometimes we have nothing to do on a Sunday, and I see a estate sale, and I take a detour with my husband, and we drive down a road, and I see somebody selling old washers and dryers and cribs and other such stuff, and it says estate sale. And sometimes it just says tag sale. So you weren't selling any of your furniture in your home.
No.
You weren't selling any of the artwork that hangs in your home.
No.
You were selling things that had been collected in your two businesses. You brought to your living room. Was it in your living room?
It was on my driveway, in my front porch.
Well, that's what I usually refer to as a tag sale, not an estate sale. That's a tag sale. That's why I asked you a definition. Clearly, we're not going to come to terms as to whether that's an estate or a tag sale. So all this stuff that you had collected from your two businesses was either on your front porch or your driveway. Am I correct?
Yes, correct.
And during what days were you selling these things? Was it a Friday, Saturday, and Sunday?
It was a Saturday, April 24th.
One day?
One day, ma'am.
One day?
Yes.
From 10 to 5?
9 to 4.
Now, at some point, the defendant, your last name is?
Thompson.
Thompson. Miss Thompson came in. Did you know her before the day of the sale?
Yes.
And that was on April?
24th.
You knew her before. From where?
She came to visit two previous times when I had sales several years ago.
Also in your home?
Yes.
Well, several years ago, you were in business.
Retired from the business, but had the business, the collectibles, so I was...
Well, several years ago, you can only retire... Well, that's not true. You can only retire once. So you knew her before, and you hadn't seen her in several years, but she had come to the second sale that you were doing at your house.
Yes.
In between the first time you saw Miss Thompson and the second time on April 24th, was there any period of time when you saw her in between?
No.
Pronounce your last name.
Honigschlager.
I got it, Mr. Honigschlager. Did you know the plaintiff?
Yeah, I've been there a couple times before. In fact, I think once or twice with Carrie as well.
Do you work together?
Well, we have separate...
Don't shake your head.
We're in the same business, but we have separate companies.
Explain the separate companies.
So she runs a collectible business mainly online. I run a collectible business mostly in music, and it's brick and mortar. It's distinctly different. I specialize in records. She specializes in all kinds of paper and furniture and lighting and all kinds of collectibles.
Okay. On the 24th of April of this year, were the two of you working together, even though she went to this tag sale?
No, I don't think I saw her that day, in fact.
What about the day before?
I don't remember if I saw her or not.
Was it you who suggested that she go to this particular tag sale?
Yeah, well, first of all, just to put, I mean, this was hardly an estate sale. This was like a glorified garage sale.
I just said it was
yeah,
a tag sale.
Okay,
I got
I'm glad we. So I gave her the lead. I gave her a tip. I go check it out. He has some posters for sale, and I didn't think much of it. I just gave her the address, frankly.
Okay. Is that exactly what happened between the two of you?
Yeah.
He didn't say to you, go there and buy stuff for me.
Absolutely not.
So you were buying stuff for yourself?
For my business, yes.
Okay. I'm going to simplify this a little, simplify the case for myself a little bit, Mr. Bertolino. You're suing Ms. Thompson and Mr. H. Hold. In what theory, legal theory, do you believe that you have a case against Mr. H in any way at all?
David Bertolino is suing his former clients, Carrie Thompson and Christian Honigschläger, for breaching a verbal agreement to purchase his collectible posters.
Did you ever speak to him that day?
Yes.
Okay.
And I have texts.
Okay. Then we will start afresh, and we will start with both defendants. So Ms. Thompson came in towards the end of the day, according to what you wrote, and according to you, made you an offer for the whole lot that was left at the end of the day.
Yes.
Tell me about that.
I was communicating with Chris and...
With Chris?
That's not true.
Just a second. Chris, Mr. H.
Yes. And by text, we were communicating. And
hey, would you show me that, please, Kevin? Show me what Mr. Bertolino was referencing.
And he said that he
no,
would...
don't tell me what he said.
Okay.
I'm looking not at what you wrote here, just at the text. This is... Are you married?
No.
Is this you saying to him, Chris, I'm not sure what's happening. Your wife came in at 3-ish. She made an offer for $4,200 for all the posters. We accepted. We closed the sale. She hands me a phone. You say you will only pay $2,500. This is not right. Hi, Chris. You asked to be texted at 2.
He wanted a reminder so he or she would come out to look at what I had available. So I called and to remind him, okay, it's getting near the end of the sale. You asked me to call you.
Oh, okay. Do you have those texts?
Those are the texts.
Well, you show me the last ones first?
No, that's the first one, reminding him that the sale is going to be coming to an end today. He wanted me to...
I wanted to see the text that came before that. Did you speak?
They were phone calls.
I hate to, simplify this, but he called me to remind me he had a sale. I totally forgot about it. I said, I'm not interested. I told Carrie, do you want to go down there? She said, I have nothing going on. She jumped in the car and went down there.
Okay. That's not your wife.
No.
No. And then the next thing you had is, Chris, I'm not sure what's happening. Your wife came in at 3-ish. She made me an offer for $4,200 for all posters. We accepted. We closed down the sale. My staff brought all the inventory to the edge. She hands me the phone and you say you will only pay $2,500. This is not right. We completed the agreed upon price and closed. We told customers the posters are no longer available. Everything was at the edge of the driveway per her request. This is not fair. The only answer I see, you are a bully and harassed her. And frankly, she said you were very creepy. Lose my number.
Absolutely.
Okay. So now, the end of the sale, Ms. Thompson is there. Right now, there is absolutely nothing contained here that suggests that she's acting for him. There's nothing contained. I'm telling you, that's not an agency. There's nothing.
She had a, may I speak?
Yes.
She had a record parlor checkbook. She said, will you take our check? And I said, of course, I've taken it before from your business. So she said, okay. She turned to the group. She turned to my assistant and said, folks, I bought all the posters.
Just a second. I'm asking you about him. I'm not asking you about her.
Okay.
Part of this case is, from just reading this, and certainly from reading the text, you are implying in this case that Miss Thompson was acting either on her own behalf or on behalf of Mr. H in buying this property. Agency. Look up a definition. Maybe I'm getting old and crazy. Don't say anything.
The definition of agency law deals with agent-principal relationships. That is a relationship where one party has the legal authority to act in place of another.
Okay, thank you. So exactly what conduct, can you tell me that implied to you, that you relied on to suggest that one party, that's her, was acting on behalf of another party? Did I get that right?
Yes.
Right.
When she arrived, I asked where Chris was, and she said, he's not available. I can take a look. I can make the decision.
She said that to you? I don't believe that. The last part of that, where's Chris? And he's not here.
Right.
He's not here.
She wanted me to let her know that she was the buyer. She was buying, as she has 2 previous times with him, Your Honor. This merchandise goes into his store.
Just a second.
That's not true. What are you talking about?
Not.
Just a second. You said that the last time, Mr. Bertolino, that you saw her was several years ago when she came to the same kind of sale. That was several years ago. You saw her one other time. What do you mean? What you're describing is a course of conduct. I want to know on April 24th what specific conduct or words were exchanged between you and Ms. Thompson or you and Mr. H that suggest that she was acting on his behalf. That's very specific.
That she was told by Chris to come.
Oh, that's all right. If I tell Whitney, next Sunday there is this phenomenal pop-up sale, on San Pedro Avenue. And Whitney goes there and says, gee, Judge Sheindlin told me to come down here and I can use her credit. I haven't made her my agent because I told her that there was a pop-up sale. You had evidently done business with him before. She came down there. What specific language did either one of them use? I'm going to ask you one more time. So far, I don't see that he's involved at all.
She said to the crowd that was there, maybe 15 people, the sale is over. None of these posters are available any longer, which the crowd was angry.
What does that have to do with him?
He sent her to
buy
the posters.
No, he didn't. Were you acting on your own behalf that day? Yeah.
Yes,
he's not an appropriate.
If you go to my online store, you'll see that I sell posters. He doesn't.
Whatever, because he spoke to him and told him when the sale was, and he told you when the sale was, doesn't mean that you're acting on his behalf, unless you have other texts for me.
If you read the text in there, he's saying, I'll only give you $2,500 for it. So if he's not interested in it, and he had no intention, why would he make that offer?
Just a second. Hold on. No, he doesn't say that, sir. You say that. He doesn't say that. You say in the text, she hands me the phone and you say you'll only pay $2,500. He doesn't say that. You say that. We completed the agreed upon price. Did you agree to pay $2,500?
Absolutely not. I wasn't there. I wasn't physically there.
I understand. But was there a time when she gave you the phone?
She called me to get a second opinion about what to do. She was kind of feeling pressured and bullied into trying to do this deal. And so she put the phone on and she said, well, what do you think about the price? And I said, what's the price? And I think you said $4,200. I said, how many posters? I think she said 2 to 250 posters. She does buyouts. In other words, she buys everything.
No, I understand.
Yeah, and I did a quick math. I said, that sounds like $20 a poster. These are C-level posters. These are not very collectible. I said, maybe for 5 or 10, it'd be a good deal. So if you get it for 2,000 or 25, maybe that's a good deal. I was giving her advice, but not
just a sec. Yeah.
Yeah, but not buying them for me. And one of the things that's kind of gnawing at me, she did not have my checkbook. She can't sign on my checkbook. He's making it up. It's just it's a wild tactic. Yeah.
Mr. H?
Yes.
The case against you is dismissed.
Oh,
you can sit
you.
down. You can stay and observe right here.
Thank
Sit.
you. Wonderful.
Sit. Now I'm going to come back to you.
All right.
You're at the tail end of the sale. It was about 3 o'clock in the afternoon.
I would say it was around 4. The sale was ended already.
No, that's not even what you say in your answer. It wasn't ended already. That's not even, if my memory is correct, that's not even what you say in your answer, that the sale was over.
I think it was him that said...
She announced that the sale was over.
Don't.
I did not.
David Bertolino claims Carrie Thompson and Christian Honigschläger agreed to pay thousands for his collectible posters, but then refused to purchase them.
Okay. The sale wasn't over. You say that you agreed on a price of $4,200.
Yes. And then...
Just a second. Okay. You said I agreed on a price of $4,200. What time had you arrived there?
Probably around 3:30.
Okay, so the sale is still on if you arrived there at 3:30. Okay, so we're changing the story. The sale wasn't over. The sale was still on when you arrived there.
When we made the agreement.
No, the sale was still on when you arrived there.
Yes.
Okay. And how many other people would you estimate were there at 3:30?
There's probably about 2 shoppers and I think 3 or 4 people of his staff he had there.
Okay, and there did come a time when you said to him, I like what I like, and I'll give you $4,200 for everything.
Yes.
Either at that time or immediately around that time, the 2 or 3 other shoppers left.
He announced to them that the posters have been sold.
Yes. He announced to them that the posters have been sold. That is a consummated deal so far.
Okay.
That's a consummated deal for $4,200. Then it appears to me, because I read your answer, that while things were being wrapped up, you were out in the car, and it was then that you called Mr. H.
So what happened was once we came to the $4,200.
Okay, so now you had an agreed-on price, $4,200, and then?
And then he told his staff to start bundling up all the posters. I didn't touch any of the posters.
Okay, which is what the staff is there for.
I asked him.
And you went outside to your car.
No, I asked him how he had posters that were linen-backed, huge ones hanging above his garage. I asked him how we can get those down, and he told me those weren't part of the deal. So that's
Just
when.
a second.
No.
Was there anything else hanging over the garage other than the 2
There
posters?
was one big one hanging over the garage, and then there was a few hanging on the line of his porch, his front porch.
What do you mean on the line?
Like he has like a front porch on the wood barriers. He had them tacked up there, and he told me that those weren't, okay.
On the 23rd of April of 2020, was one of those posters tacked over your garage? On the 23rd of April, and then I'm going to go back to the 22nd of April and the 21st of April. Did you have any poster tacked over your garage? That's either a yes or a no.
I had more than that, yes.
You had what?
I had more. I preset. I wanted to set it for the day before. So I took a picture just to say, to the staff.
Yeah, Mr. Bertolino.
Yes.
Nobody has valuable posters hanging outside their house over the garage.
Not overnight, ma'am.
Not overnight.
Just to set it.
Right. So you set the stage with having a sale. Now, were any of the other posters, those posters, by the way, Kevin, would you take custody of those posters, please? Yeah. Thank you. Just stay with them. Thanks. The posters that were hanging out online, and that were the reasons that you bought some of the posters anyway.
Yes.
Right? And you agreed to pay $4,200 for all the posters that you saw. Great.
Exactly.
Great. And you put those out, all those posters out, and your intent on putting those posters out was to entice people to your collectible sale.
No, it was to photograph it.
Just a second.
Man.
That's baloney.
Honestly.
That's baloney. You put those posters out to entice people to come to your collectible sale. And if I were to pull up to your house and see a poster hanging over your garage and stuff in your driveway and stuff on your porch and posters strung up on your porch, and I say, you know what? Everything left here, I'll take and I'll give you $4,200. And then you say, no, not that one, not that one, not that one, and that. That's deceptive, sir. So you have the following choice. I'm going to give you a choice. Either you can say, deal's over, and go and sell all this stuff again. You still have all the stuff. You didn't take anything, did you?
Nope, never paid for anything.
She gets everything for $4,200, including the posters she wanted.
Of course.
No, just a second.
Yes.
She gets everything she wants, including the posters.
Yes.
So it's your choice, because what she says is you said those posters aren't included in the sale.
I never said that, Your Honor.
Oh, okay, very good. Then we have no issue. Judgment for the plaintiff in the amount of $4,200. Give her the posters. We're done here. Thank you.
Court's adjourned.
Well, I think it's the right decision. This gal shut down my sale.
He's the one that told everyone to go home, not me.
She announced to all of the customers there, along with my staff, that the sale is over.
First of all, there was no payment made, so there was no deal.
The merchandise was going to her boyfriend's store, which is where it's been for years.
The biggest mistake I made was having Carrie go down there.
We're on eBay. We have a 5-star rating.
This guy literally does not do estate sales. These are glorified garage sales, and he's a hustler.
There's never any issues. I've been in business for 40 years.
He just kept going on and on. We have a deal, we have a deal. He just had a really creepy vibe to him.
I think the defendant's a liar, liar, pants on fire.
I thought it was a great decision. I rewarded those.
I think that Judge Judy is a great judge, and I think she's here for 2 reasons. 1, because she's very attractive, and 2, she tells the truth and she's smart.
It's a rare day that everybody leaves your courtroom happy.
That's absolutely right. I can't remember the last time. I still don't have a clear understanding of the difference between a tag sale and an estate sale. But you're right. Everybody left happy. And I did think that there was a contract, Sarah. You know, there was an offer. There was an acceptance. She now got what she wanted, which were the other posters. So I don't think that you can do a bait and switch. So I think everybody left happy. He certainly seemed happy enough with his $4,200. Anyway. Good.
Miranda Conway is suing her former friend, Joseph Ethier, for impound fees, personal property, and fraudulent debit card charges.
Court come to order. All rise.
Have a seat, everybody.
Hello, Judge. Good. Case number 1128, Conway versus Ethier.
Thank you.
You're welcome.
I want you to all know I woke up in a very good mood today. And this case is very confusing, so I'm going to try to simplify it. I've examined the complaint and I've examined the answer, and it seems to me that there are really just 2 parts of this case. 1, Miss Conway, you think that Mr. Ethier owes you for some personal property that he took that belonged to you. Actually, 3 parts. He owes you money for impound fees for a car that you allege that he took without your permission, resulted in it becoming impounded. And then you claim he used a credit card of yours without your permission. And while the bank initially reversed those charges, they subsequently put back those charges on your account. The story that goes behind this is very, very confusing to me. And I am not easily confused. So I want to find out a little something about you and you, Mr. Ethier. First of all, Ms. Conway, what do you do for a living?
I'm a personal assistant.
And you, sir?
I'm a construction superintendent.
And you know each other for a long time?
About 4 years, yeah.
How do you know each other?
We initially met in Modesto. I needed some electrical work at a store that I had out in Modesto, and that's how we initially met. And then I knew him for like maybe a year or 2 then, and then I didn't see him for 2 years until March of this year.
Now, over the course of the 4 years, did you and Mr. Ethier have any sort of social relationship?
No.
Okay. Now, Mr. Ethier, you seem to say that that's otherwise.
Yes, ma'am.
Okay. Well, let me hear the otherwise.
Okay, we met, like she said, about 4 or 5 years ago. We started associating with each other again sometime last year, and she needed somebody to go pick up a motorcycle from her in Reno, Nevada, so we got together and she took me out there and I brought her motorcycle back. We started hanging out, me and my other...
No, don't give me the whole story. I'm setting the table for this story, which is a little crazy to me when I read it. What I asked you is simple. The plaintiff says that you didn't have a social, when I say social, I'm talking about an intimate relationship.
No.
Never had an intimate relationship?
No.
Okay. I asked you that question, Mr. Ethier, because when I read your answer in this case, you know what you wrote in your answer?
Right. Yeah, I do.
So is that incorrect?
No, that is correct.
You said, I met Miranda 5 years ago. We never really dated, but became friends with benefits. Well, even I, at my age, understand what that means because I have children and grandchildren who have explained that to me. It doesn't mean that you get coupons.
I apologize. I thought you were referring to before March of this year, if we had an intimate relationship before then.
Did you have an intimate relationship after March of this year?
Yes.
You did? Okay. So before March of this year, you were just friends?
Yes.
After March of this year, you had a more social relationship. That be a fair statement?
Yes.
Okay.
Yes.
Now we've got that settled. This is your sister.
Yes.
It is your claim that at some point you moved into a house that was owned by your sister, that she was going to rent to you. Is that correct?
That's correct.
In what month was that?
March.
March of 2021.
Correct.
Did you sign a lease with her?
I did.
I'd like to see it. So far, I'm still in a good mood.
There you go. I printed it off of my email because I had her send it to me, so I printed it. That's why it's like short. That's the lease, though.
I want to see the lease, not something that you copied.
That's the lease. I had to print it off of an email.
I want to see it.
It was left in the house and taken by hand.
Then Just a second. Then if she emailed it to you, she would have it in her emails. Do you have it in your emails from March of 2021? That says either a yes or a no.
I emailed it to her in October. It was a copy of the original.
Then the answer is no.
Okay.
That becomes important. Do you understand? So this is nonsense. Take it back.
Well, I have it from March of 2021 in my...
Then I would like to see it from March of 2021.
Okay, hold on one second.
Your Honor, if I may say something?
No,
Okay.
don't say anything. Don't say anything. I'm still working on my good mood. Ms. Conway, we're supposed to have that when we get here.
I thought that this was going to be...
You thought?
You're right.
No, that doesn't tell me anything. When the issue is who had a lease to live there, then you don't show me a copy that was printed out October 9th.
This one that she sent over was May 15th.
So the answer is you don't have it in March, and she doesn't have it in March.
The original I left in a house.
Who cares? Then it doesn't exist. If you left it in your house, if you left it in a bird cage, if you left it in your refrigerator, if you don't have it here in court, it doesn't exist. And you know, when you came here, being an intelligent woman, you don't leave the one critical piece of evidence in your refrigerator at home. You bring it to court.
I couldn't because he took it.
You just told me your sister emailed it to you, the original, in March. Then you would have it in saved emails. I'm an idiot on the machine, but even I know that I can go back to the search line and I say my sister's name, and under her name comes up what she sent to me in March of 2021. We're not talking about the year of the flood. We're still talking about this year.
Right.
So if you don't have it, it doesn't exist. Now, do you have a lease?
We had a verbal agreement, yes.
So the answer is you do not have a written lease.
No, just a verbal agreement.
In what month did you move into sister's premises?
February.
Were you there before Miss Conway got there?
Miss Conway, no. She was there before me.
Okay, so she was there before February.
Yes, but she moved out. She lived there a long time before I got there. She had moved to Dunsmuir, had a residence up there. Her sister rented the place to me. I moved in there. She sold her place after I had moved in. And
who sold the place? The sister?
Miranda. She sold her place in Dunsmuir where she was living.
Oh, the plaintiff?
Yes.
Okay, so let me understand what you're trying to tell me.
Miranda Conway is suing her former friend, Joseph Ethier, for impound fees, personal property, and fraudulent debit card charges.
Now, before you moved in February,
yes,
she had been living there for a while, but then moved.
Right.
So when you got there in February, was she or was she not physically there?
No, she was not.
Okay. And when you got there in February, you had an agreement with the sister who owned the property.
Yes.
Stand. Move over there. Last name?
Simpson.
How do you know Miss Simpson?
Through her sister, Miranda.
When did you have a discussion with her about renting the property?
End of January.
How many houses are on the property?
There's a guest house in the back and then a main house in the front.
Did you have an agreement with her with regard to the guest house or the main house?
The main house.
For how much?
$1,200 a month.
Did you pay her any money?
Yes, I did.
When for the first time did you pay her any money?
February.
And you paid her $1,200?
Yes.
Show me.
I have text messages here.
Did you pay her in cash or check?
I paid her in cash. But there's a discussion of us.
Shh. Well, this is in May. I want to see February.
Okay, February, I don't have any records of that. There may, if you go to the beginning, there may be in there. I do.
Well, I see that you, Miss Simpson, accepted $1,200 from him in May. That would be a yes.
It was her rent money.
No. That would be a yes. You accepted from him.
No.
Oh, really? No. You say, so you did give me $1,200.
It was her rent money that
just a
he
second.
delivered to me.
So you're supposed to pay $1,200. This is you. And I believe that you did pay $1,200, not my sister, not my somebody else. So you're supposed to pay $1,200, and I believe that you did pay $1,200 because that's what I just deposited. There's nothing there about your sister. Don't say anything that's going to make you look stupid, because I'm a pro at that. That's my strong suit.
He was
Yes,
delivered.
you are correct. I gave you $1,200 on the dot. counted it twice to make absolutely sure. Are you getting my texts? Yes, but I'm at work now. Sorry to bother you, says he. Can you by chance give me the storage info so I can make the payment? Thank you. Shanae, that's you. Shani, that's still you. This is in July. He paid you rent of $1,200 a month. Then, at some point, sister wanted back into the house, and you let her in.
Yes.
And began friends with benefits.
Yes.
Just a second. Now I'm getting the picture.
We were friends with benefits.
Shani, I didn't do a thing wrong to her, so says he, to you or anybody else. She decides to rip me off for no reason whatsoever. She had no right to steal from me, and I have every right to protect myself from entities that are out to do me wrong or harm. You and I had an agreement on renting the house, not the three of us. You must understand that she pushed her way in, and I made the mistake of letting her in. But she moved out. I had caught her stealing my ring and my coins and other things, which she did return when I asked her to. Her reason was because she thought I was mad at her. Now I don't know what she's doing and why she's doing it. The only thing I can come up with is because of that seat. And I read something about the seat, and that's a motorcycle seat that she said she could have fixed. And when you went and had it fixed, it cost $700, and the seat was supposed to be free. So you say, so how do you think I reacted when I was told it was $700? I asked her to go back and talk to her dad because I wasn't going to pay $700 for something that cost $400 brand new. So she got mad when I told her she needed to talk to him. Now I'm stuck paying $700 with something that isn't worth $700, and I was mad. Felt that she can take my stuff, which is more valuable than $700, and hold it for collateral in a deal that made me and your uncle come to terms, which I honored. Is the uncle the one who fixed?
Apparently her uncle or father is.
Okay. I have her on camera along with you as well going through the house. Her taking my belongings to me, and you're trying to get in my bedroom. I have it on video, so I have no reason to lie about that. Nobody has any right to go into my bedroom, my personal space, and taking anything from me. I ain't tripping. What does that mean?
Yeah, I was letting it go.
But that just ain't right, and my privacy was violated. Now you, as a landlord, is inhibiting her harassment. It's not what you mean by bringing her there. I have my rights, and I have my right to privacy. Okay, but this ends up with this long text message to her. It says that she wasn't there, you took her things, and she can get her things when she makes things right with me.
Right.
Okay, and then you say, you need to call me. I tried to call, what's up? You say, my in-laws want to put their trailer in my backyard today. I need the gate unlocked and your trucks out of the way and the wood stacked against the cottage. My in-laws need to get in the back. Please call me. I have been texting and calling since 7:45 this morning. And he responds, at 11:20, I told you where the key was. Sorry. Do not be mature and hang up on me, says you. Since you won't listen, I'm going to hang up on you. Your sister started this, blank, not me. I'm not the one that decided to blank me over for no reason. She is. And you said you're not getting in the middle of things, but you really are. And now I'm the one who's paying for it. I'm just not going to let it happen. I didn't do nothing to nobody. The only way I'm going to do what you ask is if your sister gives me back my stuff. Okay. I could probably read this. It sounds more like a novel.
Miranda Conway claims her former friend, Joseph Ethier, owes for impound fees, personal property, and fraudulent debit card charges.
Now, Ms. Simpson, I want to tell you what I know, and I don't want you to try if you're smart, because I assume that if you have in-laws, right? You say you have in-laws? That's a yes!
Yes.
So I assume if you have in-laws, you also have a husband.
It's actually my son's in-laws.
So you have children.
I do.
And you don't want to look foolish in front of your children. So I want you to understand this. I know that you rented the house to him. And I know that you did not rent the house in March to your sister.
I did.
Well, I know that you did not because you nor your sister have a lease to show me in March.
Well,
I have in my bank slip that says I gave it a $3,000.
Just a second. What I'm telling you is I know that you had an agreement with him.
No, I didn't.
Well, I'm telling you, Miss Simpson, I don't believe it.
It's the truth.
Now, Not the truth. It's a big fib.
No, it's
a
not.
big fib. Then
The house
in
was rented
May,
to her in
then
March.
just a second. He was living there in February.
No, he wasn't.
No,
And
he
I-
wasn't.
Don't
I never
speak.
even-
Don't speak. He was living there in February.
No, he was not.
Really? In what month did he come?
He came around March when she moved
Just
in.
a second.
And they were having a
second.
relationship.
Just a second. So he came in March.
Yeah.
He came at the same time your sister did.
Yeah, they were
don't-
together.
Just a second. So they were a couple. Is
They
what
started
you're
to see each other.
No,
I'm not there with them all
Ms.
the
Simpson,
time.
Ms. Simpson, what I want to know is it your understanding that you rented the house to your sister and that the defendant moved in with her or that they moved in at the same time? Do not answer. What is your impression?
I rented the place to my sister, and then he came around after that. They started some kind of relationship.
Just a second. So they were both there in March.
Yes.
Okay. And did you visit them?
On and off.
Okay. And when you visited them, where did you go in the house?
I went into my house.
No, just a second. You went into a house that you were renting, according to you, to
my
your sister. And where in the house did you go? To the living room, the kitchen, the bedroom?
Everywhere.
Where did you go? Everywhere.
The bathroom, the kitchen,
everywhere.
Shower there.
And they were both there.
Did my laundry there, cooked food there.
Just a second. You did?
Yes.
Well, just a second. Why would you do all of that when you had rented it to your sister?
Because
No,
we're
I don't
sisters.
want you to say a word. I don't want you to say a word. Where do you and your children live?
My children do not live with me, and there is
Just a second. Who do you live with?
I live on that same property.
Just a second. You live on the same property. There are two structures on the property.
Mm-hmm.
There is a main house. I was in a good mood. I'm getting in a better mood. There is a guest house and a main house. Is not an answer.
Yes.
And so I assume when you say you went into the house, you were living in the guest house.
But
Don't go like this. We're not
I
talking.
had access to the main house.
No,
too.
that's not what. Listen to me. That's not my question. You may have had access. Whoever you rented the house to may have given you access because you all knew each other. Were you living in the guest house? That's what you just told me. She's going to read it back. You said I was living on the property. There were only two structures on the property, a guest house and a main. So just answer the question.
Guest house, yes.
That makes it easier, right?
Monday
Well,
through Friday.
don't speak at all because it's all coming together. Do you understand? It's not what is presented in the complaint and the answer.
The complaint is
Don't speak. This is the way your complaint opens, Miss Conway. In April of 2021, my sister wanted Joseph to build a shed for her. She had a main house and a cottage. So while he did the work, she let Joseph stay in the cottage free of charge. Around the same time, in April, that's what you swore to, I made an agreement with my sister to rent the main house. In June, now, both of you have acknowledged, as well as sister, that when, according to you, he moved in March, they started to have, according to you and according to them, an intimate relationship. And they were living together in March in the main house. That's what you just told me, right? She can read, it's not an answer.
Yes.
So all this is kind of wrong. You understand that? Okie dokie. Good. I woke up and there was a random girl in my house at 2 o'clock in the morning. I found out she was a friend of Joseph's, so I told her to leave. Do you know anything about that?
Nothing at all.
Just a second. At 4 a.m., Joseph came into my room, but you were having an intimate relationship with him, March, April.
In the room because I was so mad about this girl being there with her 9 loads of laundry and
Just a
not knowing who
second.
she was.
Just a second. He put a gun to my head and said, "Don't ever tell me who I can have over." I became uncomfortable living there while Joseph was in the cottage. Well, that is a bunch of baloney. She was sitting in, of course he wasn't in the cottage, but that's what you say in the complaint. That's what you say in your complaint.
He wasn't in the
I
cottage.
became uncomfortable living there, because this is this whole story you made up with your sister, because you did try to get a restraining order against him. Just a second. You did go to court to try to get a restraining order against him. Now, did you try to get him off the property before or after your sister went to court to try to get a restraining order against him?
Did I try to get him removed from the property before? Yes.
Yes, you tried to get him removed from the property before your sister and the police refused to put him off the property. That's a yes.
Yes.
Now, you see, it's all coming together.
To be continued.